Case number 113593, State of Kansas v. Meeks.
May it please the court, my name is Caroline Zoschek. I'm with the Kansas Appellate Defender Office, and I'm here on behalf of Mr. Patrick Meeks. If I may, I'd like to reserve 4 minutes for rebuttal.
4 minutes is granted.
This case boils down to a single question, also regarding restitution. And that question is, was the restitution plan imposed in this case workable? The state of the law is that by statute, district courts shall order restitution as part of a conviction for a crime unless the court finds compelling circumstances which would render a plan of restitution unworkable. This court has interpreted that to mean that the restitution is the rule and unworkability is the exception. And because of that, the defendant bears the burden of making a record showing that restitution would be unworkable. And workable, as Justice Johnson noted in his dissent in Holt, is workable, practicable, feasible, and Black's Law Dictionary would define it as practical and effective and feasible.
Can we back up just for a moment here in what transpired in district court? I'm curious to get your kind of take on this. As I understand it, there was restitution talked about, and it really wasn't contested that restitution was owed. It was set at around $22,000 for the value of the vehicle, which included some sort of gap insurance coverage. And counsel objected, your client objected, and basically said, no, what we're responsible for is $13,856 because that represents the fair market value of the car. And then there was some, that was the first kind of correction or objection to what we're talking about restitution. And then it appears to me that Mr. Meeks then, upon an inquiry from the court, discussed it with the judge, and the judge made an inquiry about what he believes he owes, and the court basically modified the restitution to that amount, and then included another $500 for deductible, as I understand it, to make around a $14,000 some restitution order. And then there was an inquiry as to whether or not he could pay it. And he said, not right now. I don't have anything. I'm just getting out of jail. But yes, when I land on my feet, I've got a job lined up. I can pay it. And then there was an agreement as to how much. That's kind of my understanding of what took place in district court. And so what's the judge supposed to do with that? Ignore it? And how is that an abuse of discretion to order what he agreed to do?
I think that's one reading of the record, but not the correct reading of the record.
Okay, tell me how it's wrong.
First of all, defense counsel, before the restitution was not part of the plea agreement in this case. Then before the restitution hearing, defense counsel filed a motion objecting to the workability of restitution, and she attached his financial affidavit for when he applied to receive counsel as completely indigent. And when there were two issues at the restitution hearing, the first was if they were going to impose restitution, should he be liable for the fair market value of the car or also for the gap insurance, which was for a previous car that the owners had had. And then the second question was if they were going to impose restitution, could he afford to pay it? And he went through a colloquy with his own counsel where he was on the stand, sworn as a witness, and explained that he had, I'll pull up some of the numbers, incredible debt in medical bills, college loans, $14,000 in arrears of child support, 3 kids to support. He hadn't been employed in the 5 prior years. And as a 44-year-old man, he'd spent 17 of those years in prison. He'd filed a disability claim, but it had not yet been approved for a degenerative spinal condition. And then he was relieved from the stand. At that point, probably in making a sort of Robinson type inquiry, the court started questioning the defendant separate from when he was on the bench, so when he's sitting back at counsel table. And he says, and my client at this point still wants probation. So he says they filed a motion for a durational or a dispositional departure to probation. And my client wants probation, and he believes that if he gets probation, he can go back to this town in Missouri and work immediately. Like, he can go start working right now. So he tells the court, yeah, you know, if you let me go back to Missouri on probation, I can totally start making payments. And he'll say anything to get probation. And then the court says, well, I'm sentencing you to 11 months prison, and I find that you can work when you get out, even though that wasn't actually supported by anything except his statement that if you let me go to Missouri right now, I will have a job. And then in the Court of Appeals opinion, they found, oh, he will have a job waiting for him when he gets out of prison. And I don't know about you, but I don't know many employers who hold jobs for over a year, and it was actually more in this case because this sentence was consecutive to a Missouri sentence. So I think that was a misreading of the record that he has this job ready. And also in another case where that came up to this court, the defendant presented evidence of his inability to pay restitution in a colloquy with the judge when he wasn't sworn in on the stand, and this court refused to consider it because he hadn't actually come forward with proof of his inability to pay. So if it's not considered as part of a defendant's inability to pay, I don't know why things he says off the cuff to a judge should be considered part of his ability to pay, if that makes any sense.
So you're saying if we have previously found that unsworn testimony of the defendant does not support a claim of unworkability, that the unsworn testimony also should not support a finding of workability?
I wish I had said it so clearly, Your Honor. Okay. That's exactly right.
What was the plan in this case?
$300 a month starting when he's on post-release.
Okay. And that was stated by the district court after
it was.
Hearing. Okay.
It was. And unfortunately, even if you take the best numbers that he provided, $14,000 a year, that would boil down to something like $1,166 a month. And then you take off $168 for 2 children. And I was unclear whether that was $168 per each of his children or $168 for both children. But even if you just take off the $168, you're down to $900, and $300 is about a third of that. And we know that he has no car, no bank account, no public assistance. He owned no real property. He could not afford to pay anything towards the cost of his defense. He stated that he only had the shirt on his back.
And I appreciate that recitation. And if, let's say for the purpose of this question, I agree, or the court agrees with that, and finds that no reasonable judge would find that plan was workable. What happens then? That's my question. Does that render the order of restitution itself void, or should it be remanded for a new plan? Because while that plan is, that's a lot of money to pay every month for a person in that situation. But what if it was $5 a month, or $10 a month, or $25 a month?
Well, if it was $5 a month, he'd be paying for the next 57 years. And that seems kind of unworkable in a totally different way. Like, even though that amount would be manageable, the time frame...
I guess the point is, can we imagine a plan that would be workable in this factual scenario? And if we can imagine a plan that would be workable, doesn't that mean that the restitution should still be ordered?
Yeah, we would only ask for the remand. We're not asking that you vacate the order completely. This isn't a fact-finding court.
What does workable apply to? What is unworkability or unworkable? What does it mean? It does, because our purpose for restitution is to make the victim whole and also rehabilitative with respect to the defendant. And while $5 a month might be rehabilitative for the defendant, it's certainly not recompense for the victim. If you're going to take 57 years to get it back without,
right,
it wouldn't cover the interest on the judgment. So,
What's the interplay, and what do we look at when we look at workability when it has the two-pronged purpose?
Well, Judge Liebman addressed this a little bit in the Heron decision about the competing interest. On one hand, you do have the need to make the victim whole. On the other hand, restitution is not intentionally punitive. It's meant to restore to the whole the victim. And these things have to be balanced in some way that's fair to both parties. And that's not always possible. And that's why I think the statute tells us what the test is, and that's compelling circumstances and unworkable. And
But do you agree that it's the plan that
Absolutely.
unworkability modifies the plan, not the award of restitution? Do you agree with that?
yes, but I think that's a distinction without a difference. I think if you impose a workable plan, it will also be a workable order. So, for example, $5 a month would be a workable order, but not a workable plan, because paying for 57 years would be absurd, and it wouldn't actually balance the competing interests.
Well, what if it's an amount that that, as a matter of fact, the defendant can pay per month, whatever that number is, X amount, and it's going to be 20 years, let's say. And why isn't that workable? And again, that gets to the point that it's very fact specific.
Yeah, and obviously, from the point of view of Mr. Meeks, we would oppose much less to that than we do the current plan, because if it was something that he could pay every month and he had to pay it for a long time, I'm not sure that long time is workable or that it achieves either of the goals of restitution. I mean, $5 a month for that many years, I'm not sure it actually makes the victim whole, and it still burdens the defendant.
One thing that it does is it allows for the possibility of a change in the defendant's circumstances.
Well, the review board does not have the authority to increase the amount of restitution.
Not the amount, but the plan. Doesn't it have the authority to alter the plan, and can't the order itself be converted to a civil judgment?
Yeah, the order itself can be converted to a civil judgment.
Which could then be collected if, for example, the defendant received a large inheritance, let's just say.
Again, I'm far more comfortable with that than the order in this case. I mean, we would argue that a workable plan would include both a workable amount and a workable time frame, that practical and feasible, that the plan itself needs to be practical, and that would include playing it within a feasible or effective or reasonable amount of time.
I'm not following that.
Okay.
So help me with that, because I understand the purpose of restitution is to make the victim whole. But I don't know that restitution, that is a goal. I don't know that we don't impose restitution just because we know the victim is never going to be made whole, realistically. Isn't the fact that a defendant can contribute toward something that helps make the victim closer to whole still a valid consideration and workability?
Yes.
So
I
just
didn't
the
mean to
fact that
imply.
it may take a long time to achieve whatever can be achieved, why does that make it unworkable with that understanding?
Well, I think that ideally the victim would be remade whole in a shorter amount of time, and I mean,
Ideally, yes.
but again, I don't have a problem with that the way that I have a problem with a longer time and a smaller amount is better for people in Mr. Meeks' situation than a lot of money in a shorter amount of time. So, I mean, I think Heron stands for the proposition that it's sort of ludicrous to expect someone to make monthly payments for 57 years. But if this court doesn't buy that, that's the part of the opinion that we don't care as much about that particular finding as we do that it matters whether the defendant can actually pay the amount that's ordered.
Do you have any cases or either from our jurisdiction or from out that would give district courts guidance in making a determination of what would be a workable plan or when is unworkability kind of satisfied and we need to modify whatever is owed or anything like that? Do you have any suggestions?
Well, the state of the law currently we think is a little too harsh, which is that the Court of Appeals has basically found it only in cases where the restitution would constitute over half of the defendant's income. per month. And so there's a couple of Court of Appeals cases, including Heron, Orcutt, Hambright, that suggest that half is the line. And I don't think a bright line is the best situation here. I think something more akin to the Robinson test, where you evaluate these different factors and you come to a reasonable determination based on them.
Well, we do have analogs. When you attempt to garnish wages,
Okay.
you're constrained by poverty level sort of thing. You can't leave the person with less than X amount of dollars per month to live based on some, I can't remember what the standard is, but it's a poverty level
Probably
kind of thing.
similar to my student loan payments, which are capped at part of the income level, and then they subtract from the amount, like, certain payments that can't be discharged. So, for example, his child support would come off his earned income before the poverty guidelines were applied. Is that what you're getting at, Your Honor?
Right. There are other areas where the law says that you can't leave a person without a certain amount of money upon which to live.
Right. And I think that we should.
And if this were a civil judgment, that garnishment constraint would apply. That if these victims had the civil judgment and they were garnishing wages, they could only garnish so much.
I wasn't aware of that, but that's good. I mean, obviously, for Mr. Meeks.
I just wanted to clarify something I think maybe you said earlier, maybe I've misunderstood your position. Are you saying that based on the defendant's ability or inability to pay, that under certain circumstances, there is just no point in the judge making any kind of a restitution plan because it extends out for 50 years or the person is going to be in prison for a while? I mean,
No.
What are you saying?
No, that wasn't my intention. Wasn't to state anything that strongly. Obviously, restitution serves a purpose, as Justice Lukert noted. My point was more that a workable plan to me would be something that's workable in both amount and time. So if you wanted him to pay $20 a month or $30 a month, to have him do that for a period of 5 years and make that the total amount rather than extending it indefinitely, just because that is how I read Heron. On the other hand, I take far more issue with the high dollar amount imposed on someone with no resources to come up with that amount than I do on extending a smaller amount over a longer period of time. Does that answer your question?
I think it does. I just maybe was reading too much into some of your argument.
Well, I'm passionate about him not paying more than he can afford. And however that's accomplished, I think would be fair to him.
All right. Any more questions? Thank you, counsel.
Thank you.
Good morning. May it please the court, the state appears by Assistant Solicitor General Jody Whitfin. As we've been talking about this morning, I'll just start out with restitution is the rule and a finding of unworkability is the exception, and our position here is that the exception doesn't apply. The district court took into consideration Mr. Meeks' ability to pay based on his motion for the court to do so. There was evidence presented, and Mr. Meeks basically talked the court into, I've got a job, here's how much it is an hour, here's how much I pay in child support. He talked about other payments that he had, but provided no concrete payment each month that those would have to be, and they found a workable amount. One thing that I think is interesting is in the transcript of the sentencing hearing, the judge said, I think it will be reasonable to pay up to $300 a month. So I don't know if that was the judge capping that at $300 a month and saying you can make some sort of payment up to that. But clearly it was not more than $300 a month, which if you do some math, I don't believe that would be more than half of his monthly income if he was working a full-time job at 40 hours a week.
You mean gross? Half his gross?
Yeah, estimated, yes. Math isn't my strong
We
suit.
do have testimony. I added up about approximately $44,000 in debt between student loans, hospital bills,
child support arrearage, and that doesn't include the child support that's due each month. And so it would seem to me that the disposable income, if these debt creditors wanted to garnish, his disposable income would be considerably less than what you've mentioned.
I think that's correct.
And wouldn't that be part of the plan? If you're going to make a plan, don't you look at all the facts, not just the gross?
Yes.
Okay.
And I think that it's his burden, though. I think this comes from case law, that it's not the district court's job to write out their entire budget for them and decide, well, this amount fits in this based on their, financial circumstances. I think it's his burden to write out this plan and to show this is how much I can afford, or I can't afford anything because I will never have a job and I can't work because I have some sort of disability, et cetera, et cetera. So I think it's their burden to write out this plan and propose that plan to the district court, and then the district court has to find that that's workable. And in reading Heron and some of the other cases, it appears that that's what the Court of Appeals did. They really took everything into consideration that they had presented at the restitution or sentencing hearing and found whether that was workable or unworkable. But that's not on the judge to do, it's on the defendant.
Do we consider the time value of money? In other words, if you're paying the victim $5 a month and they've lost $20,000, the time value of their loss would exceed $5 a month. You're not even covering, the loss in value of the money, much less getting to the principal. You understand what I'm saying?
Sure,
And so how can we say that that's a workable plan of restitution and they're better off when they're not even covering the time value? You understand what I'm saying?
I think so, Your Honor.
Yeah.
And I think that goes to, they're still paying something towards the victim. Whether it's $5 a month or $500 a month, they're working to make the victim whole. And that's something that the defendant said he wanted to do in this case. He said, I want to pay back what I've taken. So it was important to him, and he told that to the district court. But I think no matter if it's $5 or $500, that still goes to one of the purposes for restitution, which is to make the victim whole. And if you look at it from a deterrence perspective, if you're stuck with a payment for years and years and years, that might deter someone from stealing some expensive jewelry or something, to know that they would be stuck with this for the rest of their life. So I think it goes to both. I don't know that I have any further presentation, Your Honor. It's awfully short, but I think our position is clear that this is an abuse of discretion standard. There was no error in law here. There was no error in fact here. And I don't believe this
Is
court...
it an abuse of discretion standard if we have to interpret what workability means under the statute? If we get to that point, isn't that an interpretation of law and a de novo review as to how workability would be defined in this context?
I think generally, if we're talking about the interpretation of statutes, yes, that's de novo. But here, I think you have to look at workability within the facts and within what evidence was presented at the sentencing hearing, and find that no judge under these facts with his financial circumstances would order restitution in the amount up to $300.
If we find, if we disagree with you and we think that this plan was not workable and that the district court abused its discretion, what happens in your view? What happens to this case?
I think it would be sent back for another...
You think the
restitution
district
hearing.
court gets a second shot at a new plan?
I do if we look at the intent of the statute, which is restitution as the rule and unworkability is the exception.
This is more of a, and I know this is not developed in the record anywhere, but I'm curious here that this loss was an insured loss. In other words, the victim has been compensated for the loss of the crime, and I assume the restitution then is going to the insurance company, which really, when people are paying premiums, as I understand it, the risk pool is created, and a part of the risk that the insurance company takes and sets their premiums includes loss of the vehicle. So in some respects, everybody's been compensated for this loss that the defendant gets stuck with. Victims already been made whole by virtue of having insurance. They shouldn't be punished or rewarded for having insurance in this instance, but where is the loss in this case?
Besides the 500.
Besides the $500 deductible, where is the loss?
And that's where I was going to go first, to the
We
$500.
got $500, and I'm having trouble seeing, and I realize none of this has been developed, but this always troubled me when I had other kinds of restitution cases in my prior experience, is that lots of times insurance companies then in a civil case will file an indemnification claim, and why isn't that the remedy here?
And I think that was mentioned by the district court of, where's the insurance company? You're asking to pay them back and they're not here. So maybe that is a burden on the insurance company if there's a scenario
Well,
like
isn't
that.
that the scenario here? I mean, everything's been covered,
Right. I
and
guess,
it's been paid for.
and I guess if the court, if that would be a finding by the court, then I think that would go to telling a defendant that they can steal a car and have no
Right.
liability for its. That doesn't go to deterrence, I guess, which would be one of the purposes for restitution.
It's not that there's no liability for it. You're deprived of your liberty.
You mean just from the criminal?
Yeah.
Yeah. I mean,
it's not that there's no
sanction.
sanction imposed.
sure.
And
No.
aren't deterrence and rehabilitation kind of secondary goals of this scheme? It's really about making the victim whole. That's what restitution is.
Right.
I think they're all a part
The
of it.
definition, but the definition of restitution is that somebody gets restored to them what was taken, right? That's primary, has to be.
Right.
So it's not really an answer to Justice Rosen's question to say, well, we still want to deter them.
Well, I think it is a
because
secondary purpose. I think you can look at that absolutely. Just because it's not the primary purpose doesn't mean that that's not a purpose. I think I agree. It's a secondary purpose.
Okay.
Well,
And-
the defendant in these circumstances would have a valid civil claim, would they not? Despite the fact that they had an insurance recovery, they would still have a valid civil claim for damages.
Right.
So, at least in the civil context, there is still a loss. How
Yes.
that loss gets worked out after the judgment may be a secondary concern. In other words, the money may flow through the defendant back to the insurance company.
Right. And maybe I would go back to the statute that says that they shall order restitution for damage or loss caused by the defendant. So maybe that's what we have to link it to get. We're just looking at the damage caused. If that helps at all.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
May it please the court, I will attempt to be brief in my rebuttal. The case I mentioned earlier where the unsworn testimony was not considered was State v. Holt, decided by this court in 2017, and that's 305 Can 839. And just to touch on a few things that came up during the state's presentation, counsel for the state suggested that the defendant bears a burden of showing the plan. No, the defendant bears a burden of showing that the plan or the amount is unworkable. The plan, the restitution plan, seems to be the responsibility of the district court, because unless the district court determines a plan of restitution would be unworkable, it needs to impose one, which implies that it's the district court's duty to set up a plan, which can be as simple as saying this much a month or this much a month for this long.
What do you think the difference? I'm staring at the statute and I'm looking at the phrase compelling circumstances, and I'm trying to decide what the difference is between a circumstance and a compelling circumstance, which includes the defendant's burden. And so, I mean, the fact that a convicted defendant has student loans that cost them X, is that a circumstance or is it a compelling circumstance? You see what I'm getting at?
Yeah,
Clearly the
what
legislature's
separates a
telling us-
compelling circumstance that warrants relief from a plan versus non? And I think that's partially answered by these courts' decisions talking about, especially with prison cases, about a defendant's ability to pay in the future. So here we have a guy that not only does he have all of his debt, he has very limited ability to make money in the future because of his degenerative spinal condition and his lack of work. And I think when you consider the high amount of debt and all of the inabilities this guy has to even get a job that would pay him to support himself, let alone his children, it becomes compelling under these facts. And of course, not every case where a defendant is indigent will necessarily result in unworkability. However, here we kind of have everything you could possibly imagine working against this guy being able to repay the restitution in the amount that the district court ordered and in the plan that the district court ordered. And with that, if there are no further questions, I conclude my presentation.
If there is a remand to the district court because we held that this plan was unworkable, what is the judge supposed to be doing there different from what was done earlier? Taking on evidence, re-looking at the evidence that he has, and then coming up with something that's either less money per month or a shorter period of time, or just saying, you know what, I'm gonna order $100 to be paid over the next 5 years, period, and then we'll be done. Just help me with that.
I think any of that would work. I guess I mentioned Robinson earlier because that creates a test of like how the court's supposed to weigh different factors, and something like that might be instructive here. I mean, it's not in the statute, but it isn't in the Robinson statute either there. It's just you're to consider the defendant's ability to pay. So here I would argue that once the defendant comes forward with circumstances that show he can't pay, there should be a weighing of factors to determine what would be reasonable under the facts of this case. And it may have, I mean, if you add up the debt, I think you could come up with a number that's far more reasonable than a third of his highest possible potential income.
Well, what about the language that the court used, up to $300 a month? That's not $300 a month. It doesn't $15 a month satisfy up to $300 a month?
I don't know. I think it's really ambiguous in addition to being unworkable. So that would be something that they could clarify. If he meant, I mean, surely if the I guess it caps the amount at 300 and could be less, but it's unclear what they would consider satisfaction and how, if he paid $1 a month, that's clearly not what the court intended. So,
Any further presentation?
no, with that, we would just ask that you remand this case to the district court for the entry of a workable restitution plan.
Any other questions? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. This time.